Morning, Julie. Is my speaker turned on? Ah, okay. Is my speaker turned on? Okay. Mark is not going to be joining us today. He had a client emergency. Tom is running a little late. I am expecting Ed, um, hopefully in the next minute. Perhaps I'll just send him a text message and see.
So is it just you and I now, right, that can hear each other, or are we out there?
Everybody who's in the meeting right now can hear us, but it's mostly just commission folks.
Okay.
Hey, Meg.
Hi, Meg.
Good morning, folks.
Morning.
Ah, there he is. Okay, perfect. Right on time. Meg, sorry, I'm watching on YouTube and here, and I just saw you talking on YouTube, but that was like 10 seconds ago. And I was like, oh, you're muted, but it's fine. Just trying to remember how to do this all remotely. All right, and Ed, there you are. Great. Good morning.
Good morning.
All
Hi,
right.
Ed.
I'm going to let everybody in, and then I think we can get started. Tom is running a little bit late. He had to drop his daughter off at Logan this morning, and
What could go wrong?
yeah, right. He's going to be joining us from traffic in Boston. And Mark had a client emergency, so he will not be here today. I'm going to go ahead and admit everybody, and we can get started. I have a couple of things for you before you adopt the agenda.
Okay.
Okay. I think we are all here. Ed, do you want to get us started?
Sure. Good morning. My name's Ed David, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you, well, that's not, we're not live, so you don't, but you still should mute your other electronic devices other than the one you're on to be in the meeting. We have additional agendas, including the consent agenda available online. Consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission has voted on those cases, and they will not be considered further today. We will vote on those cases. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in the order on the accepted agenda, and as I call each case, the party who has submitted a written argument will be called will be recognized online to provide the most relevant argument in the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one relevant factual issues. Errors may address only relevant factual errors, relevant omissions from the report of facts submitted during the investigation, or three relevant issues and questions concerning interpretation of law. The commission allows parties who do not disagree with the investigator's report to rebut the comments made by the opposing party. Please be advised that the commissioners may ask questions. I'll ask you to introduce yourself as you are recognized to present. First order of business will be the agenda, and I believe there's some motions before to amend the agenda. Kit?
Yes. So the complainant in one of the cases on the consent agenda, you'll see HEDPA 25-0160, has asked to withdraw the case. Generally, I recommend that we don't after the investigation is complete. Here, I have no preference either way, so I'll leave it up to you. The effect for the complainant is largely the same, except that there would be no reasonable grounds finding on the record if you adopt the consent agenda, and a withdrawal instead if you don't.
Well, I guess I'm not sure we have much. I'm not sure we have much criteria on which to make that decision. Generally, I think I would, if they're attempting to withdraw it, I would not stand in the way of that. So I will move to allow the withdrawal in HEDPA 250160.
Second.
Moved and seconded. Any discussion? Okay, seeing none. Our remote participation policy asks the commissioners to indicate their vote both verbally and visually. So if you are in agreement with the motion, yes.
Just one question
Sure.
procedurally. To the extent we allow the complainant to withdraw the complaint of discrimination, does that therefore mean that the complainant would be barred from any future filing with the commission?
Only based on whatever facts in the case have already been investigated, to the extent that they're time barred.
Okay, thank you.
Yeah. They could certainly file a new complaint about something else in the future.
Yes, okay, thank you.
Yep. All right, so if you are in agreement with the motion, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Oh, you're muted, Julie.
You're on mute, Julie.
Yeah,
There you go.
a lot of people try to mute me. Yes.
Commissioner Sanders?
Yes.
Okay. And the second thing is not so much a motion as it is just E20, the first two cases on the hearing agenda, E23-0399 and E23-0400, are essentially the same case. The report is exactly the same. The submission of disagreement is exactly the same. It turns out the respondents are also the same. So I would recommend, they're all represented by the same people. I would recommend that we hear those cases together essentially. So just combine them into one hearing, unless the parties object, which I don't imagine they would. Be the same presentation for both cases. So I recommend that we hear those both.
Okay.
All right.
Any objection?
No.
No.
Okay,
All right.
great. Okay. In that case, I think with the amendment, we will remove HEDPA from the consent agenda, and I will allow that withdrawal. And we will hear both the Partridge cases together. I think we're ready for a motion to adopt the agenda and the consent agenda.
So moved.
Great.
Second.
All right. Any discussion? Okay. Okay, seeing none, if you vote yes, you are in agreement with the motion. Commissioner David,
Yes.
Commissioner O'Brien,
Yes,
Commissioner Sanders,
Yes.
and then the minutes for the October 2025 meeting.
Kid, I happened to notice that I went looking for them in the OneDrive, and I think they were not there, although you did send them and I found them in your email, and
Okay,
I did review them, and I find no amendment. I'll move to adopt.
everybody else got them in your email?
Mm.
Okay, great. Do I have a second?
Second.
Okay, moved and seconded. Any discussion?
I wasn't there, so I'm not,
Yeah, I think we got it. We'll have to wait to adopt the minutes until Tom gets here
Okay.
because we don't otherwise have a quorum for that.
Yeah.
So we'll hold those. Okay. Would you like the director's reports?
Yes, please.
Great. No change in personnel since the last meeting. For conciliation, we have 1 successful conciliation, 2 unsuccessful, and 5 currently scheduled or pending. And 1 agreement for you all to approve, which is E230206, Libby versus Archers on the Pier. Get a motion to approve or not approve that agreement?
So moved.
To approve or not approve?
To approve.
Great,
Second.
thank you. All right, moved and seconded. Any discussion? Okay, seeing none, if you vote yes, you are in favor of the motion. Commissioner David,
Yes.
Commissioner O'Brien,
yes,
Commissioner Sanders?
Yes.
Okay. And Barbara tells me that we have a quorum because 3 of you are here, and so the 2 of you who were at the October meeting can vote to adopt those minutes. We don't have to wait for Tom. So I have a motion on the floor to approve them from Ed and a second from Meg. Should we go ahead and vote on those?
Sure.
Okay, great. Commissioner David,
Yes.
Commissioner O'Brien, we're abstaining. And Commissioner Sanders?
Yes.
Okay, great. For investigation, we had 40 new complaints in the last month, 64 total new respondents, 33 administrative dismissals, 20 of which were administrative dismissals for lack of jurisdiction or failure to cooperate or failure to substantiate a claim, 8 right to sue letters, and 5 withdrawals with no benefits. We had 10 predetermination settlements for the total of $242,500 to complainants. I don't have the memo in front of me, but I believe you have information as to which ones were settled through the MHRC process. I can pull this up, hang on.
Yeah, I'm looking at the case activity summary, and
Okay.
I did have a question as to
Sure.
why the number of it says the withdrawals and dismissals there are 43. Why don't the breakdown of withdrawals and dismissals add to 43?
That's a good question. No, it does. 20 administrative dismissal letters, 8 right to sue letters, 10 withdrawals, and 5 withdrawals. That withdrawals and dismissals includes the withdrawals with benefits. So I think,
I see.
yeah,
That's
yeah.
6, 2, and 2 is 10. Okay, got it.
Yeah, oh yeah, sorry. So that 10 is
Yeah.
broken down here. So we
Yep.
had two that settled while the cases were with an investigator, 6 that settled through the commission's mediation program, and 2 that settled in private settlement for a total of 242,502 complainants.
Okay.
Quarterly reports. I figured out how to do the pending inventory again. So I just do it on the day. This is the pending inventory as of the day that I ran the report. So that is, I think, November 24th. 729 pending cases with an average age of 271 days. 242 of those cases are in what we call the sort of pre-review process. So they're either a complaint has been filed and we're waiting for either the answer or the complainant's reply to come in. Those have an average age of 91 days. 295 cases have been assigned to investigators and are currently with them, and those have an average age of 183 days. And the rest of the cases are just awaiting. They've been reviewed and they're either in mediation or they're awaiting assignment to an investigator.
So do you have any comment on those numbers? I mean, just looking at those numbers, I say, well, what am I seeing in terms of trend or problems or no problems or what?
Those numbers are really good, I think. That's an average number of cases for us to have pending. Usually we have between 600 and 800 pending at any one time at the commission. But an average age of 271 days means that we're well within the 2-year statute of limitations. 183 days average case age to be with an investigator means the investigator has plenty of time to finish their investigation before that statute runs. And 91 cases, an average.
Say that again, Kit.
Yep.
The average case age of 271 is within a 2-year statute of limitation. And then what about the investigators'
Yeah.
average?
So we have 295 cases that are currently with investigators. They've been assigned. The investigator is taking some action on those cases. The average age of those cases is a little over 6 months, right? 183 days, which means that the investigators have, on average, about 1.5 years to finish their investigations, which just means that we're not running up against that 2-year statute of limitations to finish the investigation. So that's
the statute of limitations requires that the investigation be finished within 2 years,
yes,
or that the decision of the commission be made.
yes, one or the other, yeah.
Oh,
That
okay.
so either that the investigator's report needs to be issued within 2 years, that means it's been published on an agenda, or some other decision, it's been dismissed, it's been settled through mediation, it's been withdrawn. One of those things has to happen within 2 years.
Okay.
For training and outreach, this is for I'm trying to catch up on these. I think we're still in Q1 of FY26, but there were 9 training and outreach events. It's a little lower than usual, but we also there's just fewer of them over the summer. Everybody's busy, everybody's away, so I expect that to pick up again. And for finance, Michael is here if you have any questions about his report. And there's Tom.
Yeah. Let me get it's the budget actuals. And I'd like to ask Michael for some comment on them. Just, I look at it and I never quite know what I'm looking for.
Yeah, if you look at the top, you're going to see the budget, the very top row, the budget. I break it down. In the beginning is state funds, the next 2 columns are federal, and the next 3 are special revenue funds.
Okay.
And on all 3 of those categories, we're doing well. We have discussed this before. Our concern is definitely with the federal funding. Are we going to receive those funds?
So those are budgeted amounts, and
That's right.
Yet to see whether they screw us over or not. All
That's
right.
right. In the federal column for the EEOC and the HUD, and that
Okay.
is yet to be determined. But if we take that expected budget amount and the expenses that we have expended thus far, we look good. We're on track to spend as we should be, according to the budget numbers.
And one can see that from the available balance is more than 75%, and this is just the first quarter report, right?
That's right. That's
Okay.
right. So this is through September. So we want at least 75 or more.
Or more.
Yep.
Okay. That's what I wanted to know in terms of how to look at it.
Perfect.
Great.
That's all I had.
Morning, Commissioner Douglas.
Good morning, everyone.
Hi, Tom.
All right, we are a little past 8:45, so shall we?
Sure.
I guess new business. I don't have much for new business. I did, when the federal government reopened, I submitted our voucher for the work that we did in FY25 to the EEOC. So that is with them. I'm waiting to hear back from them. I will follow up this week after the holiday. And for HUD, I have reached out to see what the vouchering process is going to be, and I have heard that our HUD contact was going to run that up the chain, and I have not heard anything since, so it's probably time for another email to him as well. But I don't have any update for you on those other than that they're hopefully in process. Otherwise, any questions, other questions about any of those reports? I think we're in pretty good shape. Okay, all right.
Okay, so we'll call the meeting to order for the hearing agenda. The first case on the agenda for hearing now, and we will combine the cases E230399 and E230400, and we will hear them together and consider them together as all the parties and the reports are the same. Cases are Partridge versus University of Southern Maine. The recommended findings are for a finding of no reasonable grounds on both counts. Age and whistleblower, I believe, are the two counts. The recommended finding for no reasonable grounds means that we will hear first in terms of presentation from the complainant.
Okay. And I'll just remind everybody that the commission's rules and the statute require that we keep the names of third parties confidential. So anybody who is not named as a party to the complaint, either the complainant or the respondent, you should use whatever name has been given to them in the report. So supervisor, whatever the pseudonym is there. Ms. Partridge, you have 10 minutes whenever you would like to begin. Do you want to save any of that time for a response to whatever the respondent says?
I guess I have some at the end of my spiel that I get to read.
Okay.
One
I'll
note,
start you with 10
one
minutes.
note
and-
as well. Oh, sorry, Kip, before we dive in, folks who are not muted, it would be great to go ahead and mute while Ms. Partridge gives her presentation. So thank you.
Okay. I will start you with 10 minutes and just save whatever time you have left. How about that?
Okay.
Whenever
Hello,
you're ready, go
everyone.
ahead.
Hello, everyone. Thank you for taking the time out today to be here with us today. Please be advised that my time is short to provide evidence of misconduct, hostile work environment, and more. Please save any and all questions to the end. I have provided evidence of discrimination for disability on the continued rejection of near desperate attempts of support and functional equipment such as dispatch cards, call playback access, and more, which can be found in the Word document titled Flashcards. The document Flashcards was tirelessly prepped and made after yet another surprise meeting of discomfort and disrespect towards my mental intellect and capabilities. I was given the request in meetings to write down the additives that would aid in my work's prosperity. Flashcards document was made and ignored by the higher-ups. Continual hostile environment shown through emails, text messages, and forced signed disciplinary documents. Shown below, you will you will read in emails where I have expressed need for more sleep time, work-life balance, recorded meeting times, a set schedule planned, and correct training that is USM specific in the dispatch cards, USM training, dispatch training manuals, and or response manuals, and communication that is not falsified by the higher-ups on my behalf against my strong request that words were not said by me. It is my true belief that I arrived every day with the intention to do my best with continual misinformation, sabotage, near violent encounters from my colleagues as a direct result of yet another miscommunication error and shiftly verbal abuse. While my email, text, and explanation, highly highlighted explanations tried to, with the utmost gravity, to convey just how frustrating it is to be continuously ignored and or dismissed. My whistleblower comes in where other employees also expressed discomfort in person and otherwise, where were withheld, save for the messages below. Under the hope that those so sworn to do the right thing and uphold the laws that govern our society from abuse and chaos would do so. However, it is my hope that with the few tidbits of evidence I was able to procure and showcase the unnecessary, near continual hubris of the USM public safety with their disregard to my mental and physical well-being on shift, pre-surgery, and post-surgery. This means continual harassment on and off shift, being sent mail even after, and this is snail mail, after a repeated verbal and written recommendation to not do so due to the lack of consistency on the part of USPS and mail tampering in the area, and outright refusal to meet and an outright refusal to meet on their behalf and have an arbitration or a recorded call on much needed medical leave, and 4 medical professionals ordered rest and recovery time. This harassment includes the accusations on my character, such as dishonesty and manipulative actions, even after I had complied, shown below, and again highlighted sections underlined and so forth. Regarding my outside ventures and other employment, this was disclosed to all higher ups and dispatching colleagues. It was even confirmed by email shown below by Chief Perkins of a signed copy of my book and the text between colleagues, I guess I'm not allowed to say their name, who makes a schedule and other texts from higher ups, direct supervisor. I'm not sure if she's on there either, but she's a direct supervisor for dispatch, showing that she often forgets what has been directly told to her, emailed or text in meeting with Chief Perkins, where I told her about the book, me as an author, looking for another job due to a hostile environment, which was also told to the HR of USM, plus school and working for other universities. She suggested I look for other employment within USM's network, to which I explained to her I was. In her reply email, in her own words, I quote, "It was totally unnecessary." However, weeks later, she claimed I never informed her at all. I never showed evidence of outside employment or ventures. Even after answering the question, I was still harassed. It was my purview that she was obsessed with just one of many ventures in my life. If I was indeed, again, I quote, totally unnecessary, then why the harassment? Please see the emails below. As for the claim that USM made every attempt to allow me to return to my position, there was no evidence, email or snail mail that I received that stated I could return to work. I did, however, receive many termination letters. The claim that they tried to send a Zoom call link in order to have a meeting was unfounded, as my evidence below shows repeated ask for that very thing, and no Zoom link was sent, nor recorded call made on their behalf, meaning that the USM never sent one. I was clear to them I was on medical leave and unable to return to work because of the hostile work environment, high stress, lack of sleep, and my inability to drive to Gorham, which is nearly an hour drive from Lewiston, Maine, the place of residence at the time. None of these conditions allowed any of the medical professionals in charge of my care to believe my recovery would advance while congruently working for USM public safety. Regardless of these conclusions here made here today, I will be happy to have this part of my life over and done with, allowing me to put all of this behind me. Please ask any and all questions that you may have now.
Okay, thank you, Ms. Partridge. Any commissioner questions for the complainant? Commissioner David.
Good morning, Ms. Partridge.
Good morning.
You indicated that you lived in Lewiston, and the record suggests that you took a job during this period at Bates College, which is in Lewiston. Was it essentially the same kind of job?
That's incorrect. So you have to have a specific skill set to work at USM. They make you go to training all the way up in Waterville, which is done by the state police. This for Bates only required you to have a high school education. So no, you do not need police training at all.
Oh,
It's
okay.
more like a secretary job.
Thank you. My question, and I think what's most relevant, is the physical demands on you during a time when your doctor is saying you can't work at all, and you're taking another job.
That's incorrect. So my job, my 4 doctors, both in state and out of state, agreed that at the USM was too hostile and too stressful for me to work there. I was still in school and I was still being transported to up the street. I was driven every day by Bates College. They picked me up at my home to and from, both me and my service dog. And again, it was a secretary position. And this was not after my medical leave. So once I had the surgery, I was not on any job other than school and my authorship, which
Okay,
did not require me to leave home.
Just so I'm clear, your answer to me just now was that the difference was at USM, the environment was hostile and therefore that was stressful, but the physical demands of the employment were substantially the same.
Incorrect. The USM setup would require me to use both hands, a foot pedal, and to be able to move my body. The Bates College one does not.
Okay, thank you.
You're welcome.
All right, any other commissioner questions for Ms. Partridge? Okay, seeing none, Ms. Partridge, you'll have 3 minutes and 11 seconds when we come back to you. Ms. Tizon?
I'm going to jump in. My name's Lisa Landry. I'm
okay. Great.
Ms.
Sorry.
Tizon is also here. I'm an associate general counsel for the University of Maine system, and Ms. Tizon is the senior investigations coordinator. So she is here to assist with any questions that you may have. I would like to reserve any remaining time at the end.
Okay,
for
I'll just start you. Great. I'll start you with 10 minutes and we'll say whatever you've got left.
Great. Thank you. As I mentioned, I'm the Associate General Counsel for the University of Maine system, which is the legal entity for 7 universities in the state of Maine, as you likely know, University of Southern. As the investigator noted in her reports in this case, there is no evidence to support the complainant's allegations that she was discriminated against on the basis of race, color, age, or disability, and there was no evidence to show that she was retaliated against for any activity that was protected under Maine Human Rights Act or the Whistleblowers Protection Act. The complainant has attempted to introduce new allegations, new alleged evidence in her objection to the investigator's report. And again, here this morning, UMS, however, agrees with the investigator that the complainant's allegations of race, color, age, and retaliation should be dismissed without further consideration, as complainant failed to bring forward any evidence to warrant that these allegations be analyzed in the investigator's reports. With respect to disability, UMS has provided ample evidence to show that complainant was terminated from employment for a legitimate non-discriminatory reason. It's clear from the record that UMS had a business need for complainant to be at work to perform dispatcher duties. The complainant was approved for several medical leave extensions, and that her employment was ultimately terminated because it was determined that the additional leave requested would create an undue burden on public safety. As noted in the investigator's report, the dispatchers in public safety were working significant mandatory overtime to cover complainants' leave, resulting in burnout and significant additional cost to the university. It was around $13,400 in overtime pay, just overtime pay over the summer months. The university also had a pressing need for complainants' work to be performed, given her position, and the fact that the university unfortunately had difficulty filling her position after her discharge is not evidence of disability discrimination, but rather the workforce climate that we're in. Complainant never requested any reasonable accommodation for disability during her employment and was never denied any accommodation. To the extent complainant's final leave request was considered an accommodation request, UMS has shown that this request was not feasible under the circumstances, in that it posed an undue administrative and financial burden on the university and public safety. Additionally, complainant failed to show how the extended leave request was reasonable as an accommodation. When complainant acknowledges that she was working at another college as a campus safety dispatcher at the time, she provided no evidence to show how she was able to work even part-time hours at another college, while the medical document she submitted to the university stated that she had no work capacity whatsoever. Regardless, while the university was concerned with this issue and intended to address it upon complainant's return to work, it was not the reason she was terminated from employment. Complainant was discharged solely because the university had a business need to fill her position, and complainant's additional leave request was determined to pose an undue burden on public safety and campus safety. There was no evidence of discrimination on the basis of disability or any other protected class, and the complainant has failed to meet her burden of showing a prima facie case. And I thank you, and if you have any questions, I'd be happy to answer them.
Commissioner, questions for Attorney Landry? Attorney Landry, did you enter an appearance in this case?
I did not.
Okay, we'll take your appearance today as your entry of appearance. I asked Angela because she was the only name that I saw in the file.
Yes, I came into this case fairly late in the process.
Okay.
I
Yeah,
apologize
in future,
for that.
you can just shoot us an email and let us know that you'll be representing the party at the commission meeting, and that's fine. We'll update the file from there.
I will do that. Thank you.
All right, thanks. Commissioner David, did you have a question?
Yes, Attorney Landry, are the repeated requests to extend the leave before the surgery, are they relevant at all in terms of the final decision?
I don't believe they are relevant. They were not requested as an accommodation, but to the extent that you might consider them as an accommodation request, the extensions appeared to be indefinite. There was no medical documentation to support that that she'd be able to return even after her surgery, which at that point had been pushed out to late October. I believe it was October 25th.
I
She'd
guess my
already been out
question,
several months.
yeah, did the documentation requesting the extensions give any indication of why? I mean, is this just scheduling the surgery, or is this some medical thing that's going on to see if she can avoid surgery, or we don't know?
We don't know. The
We don't know.
documentation that
Okay.
we had was based upon the surgery and the date, which was for her shoulder, I believe.
And you say you reject her argument that the work environment was hostile as a basis for finding unlawful discrimination. Would you speak to that?
I believe that was an allegation that's been brought forth late in this process. That was not part of the original complaint. And I'll let my colleague, Ms. Tizon, jump in if she knows otherwise, but there wasn't evidence of hostile discrimination, hostile environment. She did not bring that forward during her employment. And the basis and the documentation that we had for her absence had nothing to do with any allegation regarding a hostile environment.
I guess I better unmute myself. Commissioner David, does that answer your question? Okay, all right. Any other commissioner questions for Attorney Landry? Okay, we'll go back to Ms. Partridge. You have 3 minutes and 11 seconds if there's anything you'd like to respond to or anything you'd like to add.
Okay. Question, this goes back to Mr. David. Yes, the schedule had repeated changes because I am a high-risk patient. So the original surgery date was changed to the October 23rd or 25th date because it had to be moved to a Trauma 1 center. That would have been explained in a recorded phone call. However, I requested multiple times for a Zoom or recorded phone call because USM has repeatedly sent my private medical information to people that are unauthorized, including Miss Lisa Landry. I've never met this person before. These are my private medical records that I don't want being shared with people that I do not give permission for. Second, there was an HR incident with a female officer there who charged me in the dispatch room, and they were reprimanded by both departments at USM. So that was addressed multiple times. Secondly, the Zoom call was not sent by, and I did request that multiple times during my disability. As for the USM and the base, I was working congruently at USM and base at the same time before my medical leave. And this was addressed and given to multiple higher ups, including my dispatch person and my direct supervisor. So after my medical leave from both campuses, I then went to no working. So I wanted to clarify that, as well as parts of USM was notified. The benefits and department was notified multiple times. So I don't know why there is that disconnect there.
Any further commissioner questions for Ms. Partridge?
Yes,
Commissioner
please.
Declan.
Yes, Ms. Partridge, good morning.
Good morning.
Yeah, so I just want to be clear about this. I've heard you say a lot of things, right? In terms of these two jobs, right? You were working for this job that's at issue here, University of Maine, and you were working for Bates, right? After you went out on medical leave at USM, correct?
Can I answer?
Well, no, hold on. Is that correct or is that not correct, first of all?
That's incorrect. After I went on medical leave is incorrect. I was working at both of them at the same time. Once I had the surgery, there was no working at all.
Okay, so the report says that after you had your surgery, you were working at Bates, but not at USM, and you're saying that's inaccurate.
That is inaccurate, and I have the documentation to prove it. I do not want people that are unauthorized to have my medical information, but I do have that documentation that can be provided. Yes, the surgery date was changed due to me being a high risk, and I needed to be at a Trauma 1 center, even so much so that the medical professionals in Maine outsourced me because they were concerned that the medical personnel did not have the staff to have as many people in the OR with me that needed to be there. So they outsourced me to Ohio, which is where I had the surgery. And this was notified to benefit. And I think standard was the short-term disability through my medical coverage through USM. They were also notified of the surgery date change. And had there been a Zoom call or a recorded call, which was asked repeatedly, given that I was not allowed to drive, because
Okay.
I drive a clutch.
Yeah, I understand
which
the
requires
driving.
2 hands.
I understand the driving argument. So I just want to read something from one of these reports, just so we're absolutely clear about what your position is here, okay? And I'm looking at page 7, paragraph 14 of the first report that was produced. And it says, and I'm just reading this. In June 2023, complainant's physician determined that complainant, that's you, had zero work capacity due to her shoulder. However, the record shows the complainant worked for college, Bates, in a substantially similar position during the same time period that she was on leave from respondent, suggesting that her shoulder did not in fact affect her ability to perform the essential functions of her job at USM. And what I want to be crystal clear about, Ms. Partridge, is that you disagree with that. Factually, you're saying that is not true.
That is correct.
Okay, all right. Thank you. Thank you very much.
Any other commissioner questions for Ms. Partridge? Okay, seeing none, we'll go back to Attorney Landry. You have 6 minutes and 6 seconds if there's anything else you'd like to add.
I appreciate that, but we have nothing further. Thank you.
Okay. We have heard now from the parties, and next we'll hear from the investigator. Investigator Leva. Lost my script. Okay.
Good morning, commissioners. Everything that I have, again, was laid out in my report. As far as the contention about the dual jobs and the working, the information that I had and what was provided to me in the record showed that while Ms. Partridge was on medical leave, she did work both jobs at the same time, or not even at the same time. She was still working the Bates job while she was not working the job at USM. I'm happy to answer any questions if there's still anything that you would like answered.
Yes.
Absolutely.
Investigator Leva, good morning.
Good morning.
Yes. So I just want to be crystal clear about this in terms of the question I just asked Ms. Partridge. So I've read your report. I was just citing to it. The evidence in your investigative record, she denies that she was working at Bates while she was out on medical leave from USM. I mean, can you just give me a couple of sentences? How strong is that evidence? And is there any doubt in your mind that she was actually working at Bates while she was on leave from USM?
No, there's no doubt in my mind. The evidence that I had showed confirmation from Bates that showed that she was working while she was not working at USM.
All right. And in terms of these jobs being similar, we've heard a number of things. Really hard to parse through, but you've reported that the job duties are substantially similar. And I take it you stand by that statement today.
I do, yes. They both involve dispatching of calls for services.
Investigator Leva, thank you very much.
Commissioner David.
Good morning, Nuver. Not to be hyper technical, but to be hyper technical, is there a typo in your report on the date under the facts, findings of fact on page 3 under paragraph B? Says November 23. She started in 22, did she not? And then this all happens in the spring of 23, May and June,
Yes.
and that kind of thing.
Yeah,
So-
that was an oversight on my part. I'm sorry.
So you want to amend the report to that extent?
Yes.
That's all I had. Thank you.
Any other commissioner questions? Ms. Partridge, I see that your hand is raised, but the time for the parties to present is now done. Any other commissioner questions for Investigator Leva? Okay, seeing none. Thank you, Nooper. We've heard from the parties and the investigator. At this time, we would be looking for a motion. There are 2 proposed findings.
There are 2 findings on each case, and if we take them together, they're the same
Yes.
finding.
Yeah, thank you for reminding me about that. However you would like to, if you want to take the report separately or together, either one is
Okay.
fine with me.
Okay, well, I'll move that we adopt all of the recommended findings, that there are no reasonable grounds to believe that any of the respondents discriminated against the complainant on the basis of a race, color, or disability, and that there are no reasonable grounds to believe that any respondent retaliated against her for engaging in WA protected activity.
Second.
All right, it's been moved and seconded to adopt all recommended findings in both reports. Any discussion?
No, I think that the allegations in these reports speak for themselves.
And I would agree with Commissioner Douglas, and I believe I also would just comment that the documentation of it being a substantial burden to not try to fill that position is clear in the evidence in terms of the money and the mandatory overtime and the fact that they needed that position filled.
Any further discussion? Seeing none, the motion is to find no reasonable grounds on all 4 proposed findings in both reports. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas,
Yes.
Commissioner Sanders.
Yes.
Okay. All right. Thank everybody for their participation. The commission will send a letter to the parties and council confirming the results of the hearing. Attorney Landry, would you just send an email to the office with your contact information so we can get that to you?
Sure, I'd be happy to. Thank you.
Thanks.
So the next case for hearing on the agenda is E230438 A, B, and C, Picard versus Town of Madawaska. And the recommended finding is for a finding of no reasonable grounds. And therefore, we would hear first in the presentation from complainant Dennis Picard or counsel.
Good morning, Commission.
Good morning, Mr. Picard. Do you want to save any of your time?
I do approximately 3 minutes, please.
Okay, I'll start you at 7. Whenever you're ready, go ahead.
All right, I'm Dennis Picard, age 55. I was employed as a police officer in Madawaska from August of 21 to April of 23. I live in Bangor with my wife of 32 years, and together we have 4 amazing daughters. I'm currently a mental health acuity specialist at a psychiatric hospital where I train staff at all levels to respond, assess, and de-escalate mental health crisis situations. The events leading to my termination began with a shocking incident in Madawaska on November 18th, 2022. A vulnerable man in his late 60s living in a state-approved group home after release from a psychiatric hospital was subjected to possible excessive force and a civil rights violation at the hands of those who are sworn to protect and witnessed by those sworn to provide medical care. He suffers from both mental and physical disabilities and is identified as the arrestee in the MHRC report. What happened to him demanded attention. Based on my conversations with EMTs and the police chief, I did exactly what the law and my oath required. Acting on Attorney General's email advice, I submitted a letter on February 26, detailing those conversations, naming potential witnesses, and providing the necessary information for review. Knowing retaliation was likely, I invoked the Whistleblower Protection Act. Despite the risks, I refused to stay silent. On November 25th, 22, before I became directly involved, the current select board chairman warned me that 2 members of the board are fucking with you. His warning weighed heavily on my decision to blow the whistle. I knew I was damned if I did, and eternally damned if I didn't. Testimony later confirmed what I already suspected. The town manager admitted that both the ambulance director and chief failed to report the incident months earlier. The paramedic and lieutenant, mandatory reporters, failed to act and report what they witnessed to Adult Protective Services. Their failure was not minor. The paramedic acknowledged excessive force that may have caused life-threatening injuries. And the lieutenant publicly declared that the chief beat the shit out of the arrestee. Their testimony about the brutal group home incident was graphic, but they both failed to intervene as required. A student EMT testified that, get this, even if force was excessive, nobody would investigate because the arrestee was involved. The negligence left me with no choice but to step in and bring the incident to light. What would you folks do? The town EMT whom the town manager falsely labeled credible, gave conflicting testimony and perjured himself under oath. He claimed he never saw the arrestee after he returned from transport, yet booking room video recorded him speaking to the lieutenant about the arrestee and entering the arrestee's holding cell. That same video captures the lieutenant boasting about the arrestee's condition, showing staff a photo of his bloody face while the arrestee sat for over an hour in handcuffs, so tight that his hands turned blue. When the town's hand-picked investigator questioned me on March 20th and 23rd, I told the truth. I read the AG's letter verbatim at his request. I even offered to take a polygraph at my own expense to prove my honesty. The town manager rejected that offer because truth was never his goal. I was placed on administrative leave on March 31st and terminated on April 14th. The termination was delayed a week because my rep was not available. The record is clear. During repeated hearing testimony and in a letter to the district attorney the day prior to my termination, I was identified as the source of the information that triggered the investigation. Emails from March and April of 23 prove the town manager and his investigator saw me as the officer who referred the matter to the AG. He testified that my inquiries prompted the investigation. The investigation was not initiated because the paramedics' written statement, which was requested over 3.5 months after the incident. I will never subscribe to the blue wall of silence. Without my intervention, the November 18th incident would have been buried. Excuse me. I pressed supervisors from November of 22 to March of 23 to complete proper documentation and even provided use of force training to the department at the chief's request. Transparency is essential in police work. Every step I took was consistent with my oath, my ethics, and my legal obligations. For doing the right thing, I was targeted and terminated. Between May and July of 23, the Department of Labor held a 6-day hearing. The hearing officer, an attorney with decades of experience, determined that I had been discharged, but not for misconduct. Her decision exposed the truth. My termination was retaliatory and a deliberate attempt to silence me. She found that the investigator hired by the town manager lacked objectivity from the outset, giving his ties to the very officials under scrutiny. The evidence did not establish misconduct, and the weight of the proof tilted heavily against the employer. The investigator's methods revealed bias, misstated comments to favor his client, ignoring obvious follow-up questions, and eliciting contradictory statements from 6 employees. The hearing officer concluded that he had placed his thumb on the scale to protect his client. She concluded, quote, "Far from being credible, EMTs A and B appear nervous and guarded. In short, the facts do not establish that it is more likely than not that the email the claimant sent to the AG's office and the statement he made to the investigator were untruthful. The contradictions among witnesses were glaring, yet the town manager singled me out. The hearing officer concluded, quote, his obsessive focus on the claimant cast substantial doubt on his position that he discharged the claimant for being untruthful, as opposed to raising issues that the employer found discomforting. He treated the ambulance director with leniency, and after learning, he asked the paramedic to backdate an official report, but bent the rules to target me. This selective enforcement was malicious. Ultimately, the town appealed, but the Maine Unemployment Insurance Commission upheld the hearing officer's decision, confirming the employer's case was baseless. My professional record speaks for itself. I have 30 years of service in municipal, county, and state law enforcement. I worked my way through the ranks from corrections deputy to assistant jail administrator and eventually patrol captain. I am certified as a civil rights officer by the Maine AG's office, entrusted to identify, investigate, and report civil rights violations. On December 19th, 2023, I proudly appeared before the Maine Criminal Justice Academy Disciplinary Board. That board composed of chiefs,
Mr.
sheriffs,
Picard, that's
commissioners.
7 minutes. If you would like to keep going, I'll just keep your time running.
I would. I just have a couple more things. That board composed of chiefs, sheriffs, commissioners, prosecutors, and citizen representatives concluded there was, quote, no evidence of decertifiable conduct. Case closed. I was also targeted because of my association with my wife, Sharon Picard, a former Madawaska Director of Parks and Recreation. She filed employment and MHRC sex discrimination complaints against the town manager and others in October of 2022, refused to remove the town manager and board of selectmen from our MHRC complaint in February of 23, just weeks before my firing, and she was eventually heard by the MHRC on August of 24. I reserve my time, please.
Commissioner, questions for Mr. Picard? Commissioner David.
Good morning, Mr. Picard. What's the reason for the hearing before the Criminal Justice Academy? Did they hear anything having to do with use of force complaints or what?
The town, about 6 to 8, I believe it was 6 to 8 months after my termination, sent a letter to the Maine Criminal Justice Academy asking that the board review the incident, the alleged misconduct, and make a decision whether or not I should be decertified as a police officer.
So the answer is that they have the power to decertify officers?
That's correct. The Maine Criminal Justice Academy does.
Okay. And the town took that case to them, and their finding was to dismiss that case against you.
That's correct. And, their quote was no evidence of decertifiable conduct. Case closed.
Okay, and the other thing I want to ask you about, and you were just starting to say it, I want to be clear about, because I am seeing an argument that the town manager has a conflict of interest in these two cases. So I want the dates of your wife's complaint, and is that in the record here?
It should be in the complaint. If not, it's referenced in my initial complaint and has all of her information.
So when was her complaint?
Her complaint that was sent to the Maine Human Rights Commission was October of 2022.
And the nature of that allegation?
It was discrimination based on gender.
Against the town selectman and Mr. Picard?
Yes, everybody involved in my situation, the town manager, the board of selectmen, and the town of Madawaska.
Did you ever specifically make a request that he be recused from testimony because of a conflict of interest? The town manager?
I don't know that I ever asked that he be recused, and I don't recall if and when I objected to his part of the process. I believe that in nature I had.
And he's the one that refuses your offer of the lie detector test, and he's the one that chooses the investigator, correct?
That's correct.
Did you make any further allegations against the appropriateness of that investigator, that he had some bias towards the town manager?
I did, and that is part of my last 3 minutes. I go into detail about his activity behind the scenes.
Okay, thank you.
Commissioner O'Brien.
Thank you. If we can go back to the Criminal Justice Academy investigation, and I hope this is all in the record. What was the specific reason that the town brought it forth for a decertification of you?
I do not have that record in front of me. It is part of the record. Their decision, the town's decision that I was had committed misconduct by giving misleading statements is what they wanted reviewed by the academy.
Okay. Well, wait,
I'm
Jack.
sorry, I don't have that record right in front
That's
of me.
okay. That's okay. Thank you.
Any other commissioner questions for Mr. Picard? Okay, seeing none, Mr. Picard, you'll have about 2 minutes and 17 seconds when we come back to you. Attorney Hamer, you have 10 minutes. Do you want to save any of that time?
We'll see how long it takes, and if there's any time left over, then I will reserve that, please.
Okay, whenever you're ready,
Good,
go ahead.
good morning. My name is John Hamer. I'm an attorney from Roden Winchell here for the town of Madawaska. This is a kind of a complicated case because there's a lot of moving parts, but there are certain things you need to keep in mind. First is that this case is not about the use of force incident. Mr. Picard did make a bunch of complaints to the town, including the town manager, and it was his actions that resulted in the town manager selecting an investigator to investigate whether there was a use of force. And that was fine. The investigator was brought in, did his investigation. What happened after the investigation was in progress is what this case is about. During the course of the investigation, Mr. Picard contacted the investigator and said, I've got pertinent information about the case and I would like to tell you about it. And so he did. And during those statements that he made to the investigator, he made a bunch of representations about what several people who were on scene witnessed. Mr. Picard was not on the scene of the November incident, but the EMTs were because they responded. And he went and told the investigator, and all of these videos are reported. He told the investigator that I've been advised by numerous direct witnesses of an event that happened. Separately, and unsolicited EMS staff made concerning statements to me regarding police tactics used. The first expressed concerns to me that the responding officers used excessive force while placing the resident under arrest, and similar statements by the others. And that was fine. The investigator heard his statements, went on and then interviewed the 3 EMS personnel, referenced as EMT, a student EMT, and the paramedic. All 3 of those people said things that were completely different than what Mr. Picard represented that they told him. 2 of them said that they never saw the incident at all. They said that they never spoke to Mr. Picard about it, and they said they never stated that they thought that the use of force was unreasonable. The third, the paramedic, had some disagreements about how discussions with Mr. Picard arose, and basically said it didn't happen the way that Mr. Picard said it did. The investigator then went back and spoke to Mr. Picard again. Again, this was a recorded interview, and asked Mr. Picard, can you have specifics about these conversations? Do you have anything to corroborate these discussions? And he came back and basically said, I think that the witnesses are all lying, and he disagreed with what they said, but he was unable to provide any details of the conversations that he was alleged to have had with these individuals, and had nothing to corroborate his statement. So the investigator wrapped up his investigation into the use of force, and that was provided to the town manager. The town manager now has this report, including recorded statements from Mr. Picard, the 3 witnesses, and Mr. Picard again, where it is very clear that Mr. Picard's statements were either untruthful, or else he made statements without verifying them, and they were grossly inaccurate. That was the basis of the action by the town. Mr. Picard, as a police officer, went in to an internal investigation and provided false or misleading statements to the investigator about what happened at a situation where he was not present. And the 3 witnesses who were denied everything or most of what he said. And the town manager was in this position, had to decide what to do. And this was a matter that was affecting the veracity of statements. The town manager terminated Mr. Picard's employment, made the report to the DA for Giglio. The termination was eventually sent to the Maine Criminal Justice Academy because that's what you have to do with terminations. This town did not pursue decertification. That's a process that's completely outside of the town's hands. Once Mr. Picard's employment was terminated, he had he filed a grievance to the town select board. They heard his statements, they reviewed the recordings, and then they affirmed the termination. Mr. Picard's union then went and filed for arbitration. This case went to three-panel State Board of Arbitration and Conciliation for an extended hearing. Actually, it was several days of hearing, and the board determined that he was terminated for just cause. Now, Mr. Picard has been reading from an unemployment commission decision, which finds that he was terminated but not for good cause, or not for misconduct, I should say. We strongly disagree with that whole proceeding, but regardless, they're looking at a different issue. The arbitration commission found that he was terminated for good cause, and Mr. Picard had plenty of procedure in there protecting his due process rights. In the end, we support the investigators' recommended decision. The investigator had the opportunity to review all of the recordings as well as all the other decision makers involved in this case. And those recordings are the basis of the termination, not any of the protected activity that Mr. Picard may have engaged in bringing about the investigation. At that, I will be happy to answer any questions.
Questions for Attorney Hamer?
Yes. Good morning.
Good morning.
Yeah, I'm just a small point I just wanted to clarify. I understand that the EMTs didn't see the incident or didn't see any excessive force, and they said that, contrary to what complainant has said. The paramedic, however, I guess it seems from the report that she did think that the force was excessive.
It does appear that after some discussion, and yes, she appears to think that the force, it's more complicated than that because the paramedic was married to one of the people being investigated. And so she expressed her concern that if something should happen to her husband, that it would affect her, I guess it was her ex-husband, as they had shared a child. But she was concerned about whether the use of force was reasonable or not. But with that paramedic, the issue was how Mr. Picard presented the information that he received from her, and his comment was something
She
to the effect,
initiated. She initiated the conversation, right?
Mr. Picard,
She came to him, and that's not true, right? At least that's what she said.
Correct.
Okay. All right. So when the paramedic was interviewed, though, because she was interviewed by this investigator, right? And when she's interviewed, she says, "I think there's excessive force." It's not clear from this record here. Is that your understanding?
She had concerns. She did have concerns. I'm not sure what her final position is, but she's been interviewed several times since then. But I believe that she did have concerns about whether the use of force was appropriate or not.
Okay. All right. And I'm not sure if this would be on the record or not, but this lengthy days-long hearing that you referenced, did the EMTs and the paramedic testify at those?
At the arbitration, yes, absolutely.
At the arbitration, yes. Okay, thank you very much.
Thank you.
any other commissioner questions for Attorney Hamer? Okay, seeing none, you'll have 3 minutes and 41 seconds when we come back to you. Mr. Picard, you have 2 minutes and 17 seconds if there's anything else you'd like to add.
Thank you. I appreciate the council has been hired to protect the town. His effort to muddy the record cannot disguise the obvious pretext for my termination. I declined his offer to resign my position with 6 weeks back pay because I refused to compromise my principles. The evidence from the unemployment appeal hearing shows the town manager orchestrated a biased retaliatory process designed to discredit me and justify termination. By his own admission, he launched an investigation without taking notes, documenting conversations, or following policy. Hand-selected an investigator with whom he shared his own narrative. The investigator admits in an email, "I know the lieutenant and the chief are the officers involved in the incident to be investigated. I understand Dennis Picard is the officer who told someone. He makes a referral to the AG's office." He interfered repeatedly by feeding the investigator witness conflicts during the investigation, citing EMT student and chief conflicts. He provided a witness report to the chief in March, warning the paramedic used colorful language in describing the November 18th incident. The chief gave his resignation the very same day. He failed to notify me I was a target of an employment investigation, denied me union representation, and ambushed me with a redacted report that excluded exculpatory material. He sent a career damaging letter to the county DA before my termination, conducted a sham predetermination hearing, and then unilaterally decided the outcome. He applied lenient discipline to others who falsified records while brandishing me dishonest without cause, presenting unredacted evidence to the Board of Selectmen that I was denied access to, and argued against indisputable facts in grievance hearings. He openly declared EMTs more credible, despite contradictions in their testimony, while dismissing mine as lacking detail. My termination was retaliatory, not based on misconduct. Both the Maine Department of Labor and Maine Criminal Justice Academy have found no evidence of wrongdoing. I acted in good faith, consistent with my professional responsibilities. Even the arbitrator concluded Mr. Picard may have had good intentions and a genuine concern about the use of force by the chief and lieutenant. I asked the commission to rule in my favor and recognize that my discharge was unlawful retaliation. I have a better than even chance of prevailing in future proceedings. Thank you very much. I appreciate it.
Commissioner, questions for Commissioner Douglas and then Commissioner O'Brien.
Yes, Mr. Picard, good morning.
Good morning.
I just want to be clear as to what your position is on these allegedly inconsistent statements between you and the EMTs. The EMTs say, you know, they didn't see it, they didn't any excessive force, they didn't initiate any conversation with you, and you say that you did. What's your position on that? And I just want you to just focus on that question. I understand there's a big messy scheme of events surrounding all of this. I get that.
Sure.
I'm just curious about your position with respect to these alleged misstatements.
Thank you. I appreciate that. And I'd like to go EMT student, and paramedic, as I noted in the MHRC report. The town EMT, who during arbitration testimony stated over 37 times he didn't recall, was actually viewed by the paramedic viewing the use of force incident at the group home. Later in lengthy arbitration testimony, he will testify that our conversation actually could have happened at or about the first week of February, and that he didn't recall. Initially, he said he didn't remember having a conversation with me. Then he remembered that, oh, maybe we did, and he didn't recall. He is the gentleman who called the use of force unreasonable. So that's the EMT. The EMT student, who was also at the incident, stated that he didn't see anything, but gave testimony with regard to the condition of the arrestee's face. Noted that it was bloody and there was a puddle of blood under his face after the lieutenant and chief had gone hands-on. The EMT student furthers that during the transport of one of the group home workers to the hospital, he, the paramedic, and the EMT had discussions about the use of force that was used during the incident, which the EMT said he didn't recall hearing anything about it. So that in a nutshell is the EMT and the EMT student. Again, their testimony was recorded on transcripts during the arbitration hearing. And I will say the EMT student also stated that, yes, we could have had the conversation when and where I stated we had the conversation, but he didn't recall it just being me and him in the room. It may have been somebody else. The paramedic and I listened to what the paramedic had to say because she was very graphic, very emotional, and very detailed about the incident. And she likened it, and this is in the record, to the George Floyd incident. She told me that the arrestee had had a stroke just a couple months before the use of force incident at the group home. She was concerned for actually that he was going to die the night that he was arrested. She does not deny that we can converse. The when and where and how and who initiated is something for the attorney for the town has raised, only to muddy the waters. So she, in large part, verifies the conversations that we had, and it was largely based on what she told me that I decided to come forward after many times going to the chief and the lieutenant and saying, "Hey guys, we got to do something about this," you know.
All right, so let me just summarize very quickly what I think you just said. All right, so the EMT, right? Because you went through it in sort of this order here. The EMT testified at the arbitration, right, which occurred after you were terminated, correct?
Correct.
All right, so the EMT testifies after you're terminated at the arbitration that this conversation that you reported may have happened, right? It's
very much true. That's correct.
And the EMT student also said something at the arbitration, which again happened after you were terminated, to the effect of, this conversation maybe happened, but it happened under different circumstances. Like there are different people there, something like this.
That's correct. The union attorney did a great job in bringing that out.
Okay. And I think I'm pretty clear on the paramedic and what their position was. All righty. Thank you very much, sir. Appreciate it.
Thank you, sir.
Commissioner O'Brien.
Thank you. That answered, good morning. That answered some of the questions that I had, but I just want to, I believe you made a statement, and I almost like a mandated reporter, that you must, if you see something, know something, you must report it. Is that also the case, though, if you did not witness an event? Are you still required under police, I don't know, policy or ethics or whatever? Are you still required to do that?
I appreciate the question. The mandatory reporter is a requirement of anybody who's like a teacher or a
right.
And
I get that, but I'm saying just in trying the analogy of that.
Okay.
Yeah.
If you're asking about what I did and why I did it, it's because of my code of ethics, which was it's part of the record. Hear something, see something, say something, right? I'm not just gonna let it go. I was trained by the AG's office to identify that the arrestee was in a protected class based due to his mental disability, physical disability, his age, right, and where he was at the time. So that is my training coming forward. I know this from 30 years of taking ethics class, and just it's the right thing to do. It's my moral obligation to bring it forward and not let it get buried as I felt it was happening.
Okay. I think that's all. Thank you.
Commissioner David.
In that same vein that Commissioner O'Brien was just asking you, how many times did you said you talked to the police chief and the lieutenant? How many times asking them to make a report or uh, file the use of force report or whatever that is?
So that's a great question. After each and every conversation that I had with the EMT student, the EMT, and the paramedic, I went to the chief to advise him that this was being talked about. Now, this had been brought to my attention over the course of months. So I went to the chief and gave him a reasonable amount of time to act, to do a report. He didn't even do a written report on the incident. So that's what I did. I even, after the Christmas party where the lieutenant proclaimed that the chief had beat the shit out of the arrestee, I went to the chief the next day and I said, "Hey, man, you know, this is the kind of thing that's going to come out and bury our department. You need to act on this. You need to do something. This event happened and it wasn't recorded and documented the way it should have been." So at least 4 times, sir.
And that's before you took the action that you took, which was specifically what? Who did you file a use of force report with?
I contacted the Attorney General's office
Attorney
with
General.
all of the information of what I had heard, who
Okay.
told it to me, and what the
Right.
circumstances.
So the action that you took was to file the complaint or the description of what you perceived to be improper with the Attorney General. That's what I'm focusing on. That's where you filed it.
That's correct. After I had raised the complaint through my chain of command as is policy.
Okay. Over a period of time, over a number of times, raising it internally before you took that action.
That is correct.
And you
From
mentioned
November to February, sir.
Thank you. I didn't recall, but you said in your presentation that somebody made you an offer that if you'd resign, they'd give you some back pay and we'd all go home. When was that?
That was maybe the counselor for the town can help me recall this, but this was prior to arbitration that the offer was made. I wasn't having it.
This is after you've been discharged?
That's correct.
Oh, I see. This is an offer of settlement of the other cases after you've been discharged.
That is correct.
Which would have required a release and end of all of those other cases, correct?
Yes, sir.
Okay, thank you.
Any other commissioner questions for Mr. Picard? Okay, seeing none. Attorney Hamer, you have 3 minutes and 41 seconds if there's anything else you'd like to add.
Yes, thank you. Good morning again. So demanding an investigation was not the problem in this case. Mr. Picard sent a letter to the AG in February, but the AG never contacted the town. There was no knowledge on the part of the town about that letter until it was disclosed to the investigator that was already being conducted by the town. When Mr. Picard made his complaints, it eventually made its way to the town manager. The chief didn't do anything, and the lieutenant didn't do anything. But when it got to the town manager said, "Yes, it looks like this is something that should be investigated." The town manager then went and hired the investigator, an outside investigator, to conduct the investigation to see if excessive force was used. The ultimate conclusion was that no excessive force had not been used, but reports should have been filed by the chief and by the lieutenant. So that's how it all got started. And the town completely recognizes that Mr. Picard was instrumental in getting that information to the town manager so that an investigation could be done. The problem is the statements Mr. Picard made to the investigator during the investigation, when he did not view the situation himself. and was acting on behalf of others allegedly, and made statements, attributed statements to the three individuals who then explicitly denied in whole or in part Mr. Picard's statements that he attributed it to them. And when the investigator went back and spoke to Mr. Picard again, Mr. Picard had no specific knowledge of any of the conversations. He gave me the opportunity to say, to explain how did these conversations get initiated and what was said. And Mr. Picard said, I just don't remember. I don't know. It was based on these inconsistencies that the town manager then believed that Mr. Picard either provided untrue or misleading statements. Mr. Picard never went back and verified any of the information that he attributed to the EMTs or the EMS people before making his reports to the AG or to the investigator. He just didn't do what a police officer should have done, or anybody in the course of an internal investigation. That is to make sure that the information that you are presenting, especially on behalf of other people, is correct. He did not do that. He misled the investigator. He clearly has a very strong feelings about the incident, and he was focused on that. And the information he provided was incorrect, and it was denied by the three witnesses, not just one, but three. And that was the basis for the termination. It had nothing to do with the fact that Mr. Picard pressed to have an investigation, and the town manager agreed that an investigation was appropriate. It was the quality of the statements that resulted in the termination. Okay. Any other questions? I'm happy to answer.
Commissioner Douglas.
Yes, thank you. So I get that the town knew what it knew when it terminated Mr. Picard, right? I get that. I mean, we have two EMTs who are saying this conversation never happened, right? And then he gets terminated. The paramedic says, I never initiated any conversation with him, right? And so we have all this. But in terms of assuming there's a trial in the future in this case, right? And it's sort of evaluating the even chance standard here. I just wanted to give you an opportunity to respond to Mr. Picard's statements this morning to the effect of, at the arbitration, the EMT said, oh, yeah, maybe this conversation did happen. It may have happened, I think were the exact words. And the EMT student saying, this conversation maybe could have happened under reasonable circumstances. Do you want to address those?
Sure, absolutely. And it's worth noting that, again, the arbitration panel found that Mr. Picard was terminated for good cause. And that includes an underlying acceptance of the EMT's statements that A, I didn't even see this incident, and B, is it possible I ever spoke to him? Yes, possible I spoke to him. That doesn't mean that they had a conversation about the subject of this dispute. The three individuals were very clear that they did not see the incident at all, did not express an opinion, and that while they may have spoken in passing, never approached Mr. Picard to say, I have concerns about what's going on in this case. So I'm not concerned about the statements of the EMTs. They were very consistent. They have nothing to gain by appearing. They had no reason to be untruthful.
Okay, thank you.
Commissioner O'Brien and then Commissioner David.
Thank you. I'm trying to put myself in the position of Mr. Picard, and ethically, morally, if there was excessive force, I would not be able to sleep without saying something. However, your issue is not that at all. Your issue, if I can parse this down, is that he did not tell the truth in several instances. And I'm not sure you're able to answer this question, but do you see another motive? Do you see a motive here to do this, to pursue this incident?
I have my own ideas, but I'm not going to speculate.
Commissioner David?
Attorney Hammer, the EMTs don't, I mean, they come to the scene because they're called. Does the record contain any statements by the officers? Are they ever investigated, or is there any disciplinary action investigated against them?
Yes. So the investigation that was conducted by a former, doesn't matter who it was an outside investigator who came in. The investigation was of the chief and the lieutenant. The whole point of the investigation was to determine whether they used excessive force in the course of the arrest.
Are the
So,
chief and the lieutenant the ones that made the arrest?
yes.
So the
that was,
allegation is against them that they used against excessive force.
yes, that was the complaint. And so the investigator spoke to the chief, the lieutenant, the people who were on scene, and it was in the course of this investigation that Mr. Picard contacted the investigator and said, "I have pertinent information." And that's the context for those statements. But yes, the chief and the lieutenant were both interviewed, and the ultimate decision was that they should have filed a report, but that there was no excessive force.
As a conclusion by the investigator that the town manager hired.
Correct.
Thank you.
Other commissioner questions for Attorney Hamer? Okay, seeing none. Next, we will hear from Jane O'Reilly.
Good morning, commissioners. As you know, my name is Jane O'Reilly. I was the investigator on this case. And before I go into some of the sort of facts, I want to be clear on the sort of timeline and the record in this case. So again, Mr. Picard's presentation today is sort of a summation of his entire position and his sort of feelings about what's been going on. But my investigation really needed to focus on the reasons for his termination. So included in the record was the information about the conversations he was having, or his recollection of the conversations he was having with his coworkers and supervisors. So the incident happens with the arrest. Some amount of conversations happen where he is talking to his supervisor, the chief, saying either, "I think you need to file a use of force report because maybe it's use of force, excessive use of force," or he's saying there might be excessive use of force. It was sort of unclear specifically what he was reporting, but that's definitely one of the topics. Then there's an investigation done by this third-party investigator. Then there is several meetings before his termination. So in addition to the investigation, the town manager then has to go through the process to terminate the employee. So Mr. Picard met with the town manager, and the town manager asked him to talk about this interview and said, "Look, these look inconsistent. Do you have anything else to add?" Mr. Picard at that time didn't add any new information. He didn't add new specifics. He said, "This is what I said. I was truthful. I stand by what I said." Then there was a second hearing with the town board of selectmen. The board of selectmen also, that was another opportunity for Mr. Picard to talk to the board of selectmen. The town presented their position with Attorney Hamer. So the town manager was there sort of presenting his position on why he was in support of termination. And then the Board of Selectmen voted on whether or not to support that decision. So there were multiple levels before we even get to all the stuff that's now being discussed this morning, which mostly happened post-termination. So post-termination, a lot of the stuff that Mr. Picard is quoting happened at the unemployment hearing, which I listened to all of the interviews for. They were submitted and read the decision, and an arbitration hearing. Both of these were multiple days, everybody being re-interviewed. In addition to, I watched the initial videos of the initial interviews. All of the initial interviews with the third-party investigator were recorded. So the timeline of this case is lengthy, but to the extent that information that was brought up later is as important as the information that was brought up prior to the Mr. Picard's actual termination, I weighed those in terms of, reasons for why and facts that were being brought up and how long it had been since people had, been present for these events. The other thing I want to mention is once again, there are a lot of feelings about this particular arrest and whether or not the use of force in the arrest itself was excessive. That was not something my report could determine, right? My report was looking at whether or not the reason that the town stated for terminating Mr. Picard was its actual reason, or whether or not they were retaliating against him for making a protected report. So, you know, I do think that the paramedic in particular, that her perception of the event has been a little bit downplayed in respondent's presentation. She definitely was very concerned. She may not have used the phrase excessive force, but she was dancing around that term. She definitely thought it was maybe more than necessary. She brought up that she was concerned about the fact that this particular arrestee was well known at the department, had a lot of arrests at the department, and had previously had a recent head injury. So she was in particular concerned about that, and made a report to her supervisor directly after it happened. She went and spoke to the EMT director directly after it happened and said, I think that this was not appropriate. I think something was not okay. And it was later, and that EMT director didn't do anything with that report. So I'm getting there's a lot of information in this record, and it was really important to focus on the specifics of what question I was being asked to answer. So keeping that in mind, there were a few things I wanted to point out in terms of the questions that were asked by commissioners already. So the reports that were made, both to the Criminal Justice Academy and to the DA, in footnote 6 in my report, I talk about those. Both of those were legally mandated. Basically, whenever an officer is terminated for anything that might implicate sort of misconduct or untruthfulness, a report must be made to the district attorney and a report must be made to the Criminal Justice Academy. Whether or not, you know, the Criminal Justice Academy found that there wasn't anything that he would be sanctioned for, that's all part of the record, but those reports themselves were not motivated by anything other than the town's belief they were legally required to make those reports. And I think this has been pointed out a couple times, the inconsistencies about the statements in the interviews were not about the use of force. The inconsistencies were about the conversations that Mr. Picard had with the EMTs. And again, I watched those interviews. I saw the questions being asked. You know, I didn't see any reason to believe that the EMTs were being untruthful. Let's see. Oh, and the last question, how did the town know? I think there's been a little bit of confusion around how the investigation was initiated. How did the town become aware of the issue? And the town became aware, so complainant had been bringing it up multiple times. The town was not aware because of the AG letter. So complainant went to the AG because he felt like the town was not being responsive. And the town manager had, you know, weekly meetings or monthly meetings or regular meetings with the chief of police, who said to the town manager, hey, Mr. Picard has been talking about this a lot. He's been bringing it up to me a lot. We've got this issue going on, just so you know. And the town manager said, oh, well, if we've got an issue like that, we need to do something about it. Town manager talked to EMT director, who reported that he had gotten a report from paramedic right after the incident, and that's what made the town manager initiate the investigation. So at least according to my read of the record, what evidence has been provided, that's how I determined the issue actually got to the town a couple of months later when the investigation was actually initiated. That is a lot more talking than I normally do, and I'm happy to answer any questions.
Commissioner David.
Morning, Jane. What was the report that the EMT director got from his EMTs? Is that in the record?
Yeah, that she thought the use of, when he was arrested, that he might be injured. I don't know if she reported.
Might have been injured as part of the arrest.
Yes. Yeah, she felt that there wasn't enough. She was concerned about the health and welfare of the arrestee. Because of the conduct around the arrest. Correct.
Which is being characterized as excessive use of force. Clearly, he was injured, right? I mean, we needed EMTs, which you don't need for.
Well, so
putting somebody in the cruiser and taking them to the police station.
So a couple of things. The EMTs were called because during the arrest, the arrestee had pushed someone down the stairs. So they weren't called to the scene because arrestee was injured. They were called to this. When they got there, the arrestee was just sitting outside. They had relocated him from the inside of the building. They were attending to a patient who was inside, who had been pushed down the stairs. So they brought that individual to the hospital. And what the paramedic reported was what she saw on the porch, which was arrestee face down on the porch, being restrained by chief and lieutenant, and her concerns around that. And then also when she came back to so after they had taken the patient to the hospital, they came back to the police station. And when they returned to the police station, the arrestee had facial injuries, appeared to be, she felt he appeared to be a little bit lethargic, like his speech was slurred. She had some concerns about his welfare at that time. So those are the things she reported to the, and he was taken to the hospital. He was taken to the hospital after his arrest. He was in the police station for an hour, and then he was taken to the hospital for assessment and then brought back to the police station.
Do you know anything, Jane, about the other complaint of his wife to the commission?
Yes, I'm aware that Mr. Picard stated that was one of the reasons he felt he was being retaliated against. That was not brought up until after his termination.
Yeah, but is it in the record? Do we know
Yes.
what that complaint? What was the nature of?
So I'm aware of in terms of what he provided in the record. He provided that his wife made a complaint against the town. That case is public record within the commission.
What was the nature of that complaint?
The nature of the complaint was a sex discrimination complaint in employment.
By officers of the town?
She named the town manager and the board of selectmen as her respondents, yes.
And that's the same town manager that's named here?
Yes.
Okay.
Yeah, I just wanted to clarify, Jane. First of all, excellent report. And it seems like you took a very deep dive, very good thorough dive into this case, and we all appreciate that. This individual you were just talking about with Commissioner David that filed the report, that's the person we've been referring to as paramedic, yes?
Correct.
Okay.
Correct.
Thank you.
Yep.
I'll just dive in. Jane, as you said, this is there are a lot of moving parts here, but tell me if I am reading this wrong or whatever. Did this come down to a matter of credibility?
Credibility, and I think so. I was looking back as the presentations were being made about what specifically the investigator wrote in his report. So about his concerns about Mr. Picard's involvement with this investigation, and it was not just the credibility, but sort of the lack of detailed follow-up. So he interviewed Mr. Picard at Mr. Picard's request. Mr. Picard read his attorney general, the letter he wrote to the attorney general, and he talked about what he talked about here, that he had a conversation with paramedic who was concerned and who likened it to the George Floyd incident, and all of these different things. But he didn't have specifics on when and what was said by the other two medical individuals, the EMT and EMT student. Then the investigator talked to the three individuals who the paramedic said she had talked to Mr. Picard, but it was not of the nature that Mr. Picard had said, that she was basically talking to somebody else, and he came in and said, oh, more information about this. And the other two said they had conversations with the paramedic, they sort of, but they had never had conversations with Mr. Picard. Then he talked to Mr. Picard again, and Mr. Picard didn't add any additional information. He didn't have specifics, he didn't know when, he didn't know where, nothing to sort of follow up on those conversations. And that seemed to be, let me see if I can find it actually, because I don't want to mischaracterize what he said in the end. So he has a couple of statements. It says, for some reason, Officer Picard put great effort into making sure this incident was investigated, an incident of which he admittedly had no direct knowledge and for which he has no responsibility. Yet when asked to provide basic details about what he was told by two of the alleged witnesses that prompted his efforts, he said, I don't know, I didn't write it down or record it. Mr. Picard is a tenured police officer with presumably at least a basic understanding of conducting interviews and investigations. If Officer Picard deems something credible and important enough to communicate a report of suspected crime and cover-up by his superiors to the Office of the Attorney General, I would suggest it would also have been worth jotting down a few notes of exactly what he was told. And then at the very end, it says, I find suspicious and troubling Officer Picard's failure to recollect basic substantive details of his alleged conversations with, and then he lists the names, as well as his failure to remember details of how his most recent conversation with paramedic took place. So he's, yes, credibility, but a little bit more than that. It's sort of a high, he's holding him to a standard of, if you're going to report a violation of law, crime, these types of things, I would expect more details. Again, that's not my assessment to make as to whether or not that was appropriate. I did listen to the interviews and I do agree that Mr. Picard, when given the opportunity to provide specifics, didn't do so. And that was troubling to the town. And I found that what I did find was that it was that part of it that was troubling to the town, and that part of it, when they went back to him 2 more times after this to provide more information and he didn't, that was the reason for his termination.
Excuse me. Any other commissioner questions for Jane? Okay. And just for reference, I know it's come up a few times. We heard Mr. Picard's wife's case in August of 2024. We have heard from the parties and the investigator. At this time, we are looking for a motion. And help me out. I've lost the report. How many proposed findings do we have?
There's 2, both retaliation, violation of Maine human rights protected activity and WPA protected activity.
Okay, so 2 proposed findings. Do I have a motion?
I'm not going to make a motion in the affirmative. I'm tipping my hand here.
So what happens, kid, if no one makes a motion?
Well, somebody will make a motion after a while.
I start singing the Jeopardy theme song until somebody makes a motion to shut me up.
Well, Ed's going to make a motion.
Great, go ahead.
My motion is contrary to the recommendation. My motion is that we find that there is reasonable grounds to believe that there was unlawful discrimination in the form of retaliation, both for Maine human rights protected activity and for WPA protected activity.
Do I have a second?
You know what? I'm gonna second that motion for now, but mostly because I want to hear what Ed has to say about this.
Okay.
Agreed.
Honestly,
Seconded.
I'm not sure which way I'm going, so I
right.
want to hear what Ed has to say.
Great. Discussion.
I hear you. I hear you, Tom. And I was, I read this a couple of times and was torn about it in my own notes. It's as likely as not that he will prevail. He's a whistleblower. He's trying to report an incident, and he's faced with a cover up, and these stretching for saying that there's grounds for termination for intentional misrepresentation about these inconsistencies of hearsay on hearsay on hearsay are pretext. This is a cover-up, and it's not for us to sort that out. It has the ability to be proven to be a cover-up, and so that's why I'm saying that we should not dismiss it out of hand and say that there's no grounds, no possibility of success at trial.
Yeah, you know what, Ed, I hear that. And I don't necessarily disagree with any of that. I found myself thinking during the presentation of all this that as a trial lawyer, this would be a really interesting case to take to trial and present all this evidence and see what a jury would do with it. It seems like nobody likes anybody in this case, right? There's an issue with, I mean, but certainly, Mr. Picard's wife has an issue with the city manager, or therefore the city manager has an issue, the town manager has an issue with him. And then, there are these EMTs that are not talking And then maybe later they say, oh, I don't know, maybe that could have happened. Who knows what a jury does with that? You have a paramedic that says there's an issue here. And then on the other hand, I'm kind of sensitive to the fact that if this was on the up and up, right? If they did interview these people, they hired an independent investigator, they interview the EMTs, then they say, I'm not, I never had a conversation with the man, right? And so I guess for me, on the one hand, excessive force by the police is a serious issue, and that merits serious consideration. I think we want our police force to be honest and trustworthy, right? And that's another serious issue. And given all the dynamics in this case, I don't know where it comes out at trial. So maybe I end up where you are,
Right.
Ed,
Right. And so I come down to being impressed with Mr. Picard's presentation and his concern that this really needed to be investigated and looked into, and that it's being swept under the rug. That he tried to make the complaint to the chief and the supervisor. That business about the investigation, I think it's questionable whether that individual that was hired has some vested interest in knowing where the report ought to come out, whether there's some connection between the town manager and that investigator. I just think that well, yeah.
If I had to guess, right, I would conclude that a jury is going to find that Mr. Picard learned of this incident, and this is just me speculating, which is worth what it's worth. But I think that a jury is going to find that Mr. Picard learned of this incident and wanted to get it in front of the brass, the appropriate folks, and maybe cut some corners to do so, and was terminated for that.
Right. There's no other indication for termination other than those alleged inconsistencies.
Right, and in the meantime, his wife's got a complaint against the same guy that fires him.
Absolutely, I think there's a conflict there.
Yes.
Megan looks poised to
Yeah,
comment.
Come on, Sanders.
So
come on, Megan.
Come on,
so
Sanders. Very quiet this morning.
what's not before us, right? We're not making any determination about the underlying, veracity or legitimacy of, use of excessive force or not, right? It's also not before us, right? Whether the report, sort of this whole business about reporting to the Attorney General was appropriate or not, right? We all agree, I think that's an appropriate action,
Yeah,
right?
yeah.
So he's protected for whistleblower status, fine. Then we get to the matter of the interview, right? Or series of interviews that he had in the context of, sort of the town assessing, what did an appropriate investigation look like, right? So he's interviewed. Whether he embellished, right? Whether, Tom, to your point, he cut corners, whether there was intentionality, right? Did he lie? Did he engage in misrepresentation, right? In response to the investigator's work? To the extent that there's a credibility assessment that was made, which there was, right? That in fact, he had not been truthful, not mistaken, right? That's different from not being truthful. That's a problem to the extent that we have a member of law enforcement, right, where there's a concern about truthfulness in a legitimate proceeding on the record, right? There are serious issues and challenges associated with sort of the stain of not having been truthful in a law enforcement capacity in connection with an internal investigation, to the extent that that happens, and certainly Tom, in your work with juries and in trial work in particular, right, that's going to be an issue that follows him throughout the course of the remainder of his career, posing legitimate and concerning credibility issues. So I don't see any evidence in this record, and it would be entirely speculative on our part, given the fact that Jane did a comprehensive investigation, entirely speculative on our part to assume, to draw a conclusion. I think that the town manager or anybody who played a role in investigating this matter had motive, right? Or there's pretext here. Motive to retaliate against Mr. Picard with this fact pattern, right? There have been statements about perhaps the lack of independence of the independent investigator that was appointed to do this work. I just haven't seen any evidence, right, that that's in fact a legitimate worry or conclusion that we could draw. So on that basis, I'm not convinced that we do or we should or there's evidence to find reasonable grounds here.
Yeah, and we got to get to a vote. I think that I agree with just about everything you've said, Commissioner Sanders, which is rare. I'm joking, but I'm just making a joke. But in terms of his motive, again, his wife had sued the town manager for sex discrimination. That came out today. So in terms of motive, I think that's pretty easy to establish a trial that he had a motive to act the way he did.
He's
Anyway,
a troublemaker in this town.
Yeah. So anyway, Commissioner O'Brien, you want to weigh in? You're the last one.
Yeah, I know. Mark's not here. I thank you, Megan, for your eloquent soliloquy. You basically said what I was thinking.
Okay. Any further discussion? The motion is to find reasonable grounds on both recommended findings. If you're in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
No,
Commissioner Douglas,
I'm gonna vote yes. Yes.
Commissioner Sanders.
No.
Okay, so tie vote reverts to the investigator's findings. So the findings are no reasonable grounds on both counts. We thank the parties and the council for their participation, and the commission will send a letter confirming the results of the hearing.
We'll be in recess for 5 minutes.
Great, thank you.
All set, Kip?
All set.
Okay, we'll call the meeting to order again. The next case for hearing is E230469 Eric Leffler versus Eastern Events, and the recommendation is for
All set, Kip?
a finding of reasonable grounds, and therefore we will hear from respondent.
Commissioner David, one
Yes.
moment. This is a matter I need to recuse myself in, so I'll put myself on mute and stay off camera.
And we don't have, Mark has not been able to join us yet, right?
Mark will not be here today. He's
Well, no, was not going to come. It was Tom that was, yeah, okay. All right, thank you, Megan.
All right, Attorney Haley, do you want to save any of your time?
I will just reserve whatever is left over after my initial presentation. Thank you.
Okay, it's a little hard to hear you.
I'll just try to speak more loudly. If
Okay.
That's okay.
Sounds good. All right, whenever you're ready.
Audio at this point. Thank you. Good morning, commissioners. Thank you for your time today. In this case, respondent acquired a rental equipment business in approximately July 2021. The business had been previously family owned and operated for over 65 years. And at the time of the acquisition, respondent retained all employees, including complainant, who had served as store manager at the location for approximately 6 years. As is the case with so many acquisitions, respondent had a vision for the equipment rental company and established strategic initiatives, implemented regular team meetings, and prioritized succession planning because of the specialized knowledge and tenure of so many of its employees. Complainant was one of approximately 4 employees for whom succession planning was implemented. Complainant's retirement timeline kept changing, but respondent made it clear at all times that it was ultimately complainant's decision to retire. The timing of the decision was his own, but of course that is not a guarantee of employment for any period of time. At all times, complainant remained an at-will employee. Complainant has admitted that he and respondent discussed succession planning, including in 2022 and in January 2023, and he was quote unquote all for it. However, in reality, complainant was not all for it. Much is made of a conversation between complainant and his supervisor in approximately May 2023, in which complainant asked for time off to celebrate his upcoming 66th birthday. And in response, supervisor granted the time off request and said, "Wow, I thought you were 60. You look great." Supervisor meant the comment as a compliment. Complainant interpreted the comment as a compliment and said that in his submissions. And it was only after his separation of employment that complainant has assigned some sort of discriminatory intent to such comment. Shortly after that comment or that discussion, in approximately June 2023, complainant directly told his supervisor that he may retire in as quickly as 6 months. And this comment was part of a conversation and complainant admitted during the Issues and Resolutions Conference to making the quote unquote 6-month statement, testifying that he and his supervisor had a conversation in which he said, "You never know how much time you have how much time you have," and quote unquote, that's where the 6 months came from. Respondent's director of HR testified the complainant directly told her that his retirement date could be anywhere between 6 months and 3 years. Around the same time as this conversation, in June 2023, complainant and supervisor together decided to terminate the employment of a rental counter representative. Because complainant had recently said he could retire in as quickly as 6 months, and you never know what could happen, respondent made the legitimate business decision to begin the job search for a store manager to train with complainant, because training would necessarily include significant time working at the counter rather than replacing the rental counter representative role 1-for-1. In her report, the investigator found it implausible that respondent would employ SM2 as a trainee to shadow and learn from complainant for an indeterminate length of time. However, that finding is not supported by the record. In her report, the investigator ignored the fact that the complainant himself made a comment that he may retire in as quickly 6 months, and also attributed pretext to the fact that the job posting itself did not include the word trainee. As the saying goes, you dress for the job that you want, not the job that you have. Supervisor testified in the IRC that all job advertisements that were part of succession planning for multiple employees were designed to attract talent, and none of the job postings that were part of succession planning included the title trainee. Respondent also testified that has implemented approximately 3 other succession plans with training components, and both the tenured employee and the training employees have remained employed by respondents for months, if not years at this point, without set retirement deadlines. SM2 also testified that respondent made it clear to him in the interviewing and onboarding process that he would be training under complainant, and that there was, quote, no timeline whatsoever, unquote, and that he further testified, quote, could mean 5 years, could mean 10 years, unquote. Complainant himself testified that SM2 affirmatively identified himself to customers as a manager trainee, and that it was complainant, not respondent, who instructed SM2 to stop telling customers that he was a trainee so that he could convey the authority of a manager. Moreover, complainant alleges that respondent terminated his employment as soon as SM2 was trained, but both SM2 and supervisor testified that SM2 was not trained as of complainant separation. The investigator also stated in her report that supervisor justified not including complainant in the hiring process by saying SM2 would, quote, eventually report to him directly. Nowhere in the issue and resolutions conference does the word eventually come out of supervisor's mouth. What he said was that SM2 would ultimately report to him, as in he's the co-owner of the entire company. I think the attribution of the word eventually to supervisor is a significant error on the investigator's part. Complainant, even before hiring SM2, complainant had a history of undermining his supervisor, having an attitude of knowing better than his supervisor and others. For example, his supervisor asked him to solicit business by visiting customers in person and making outbound calls. During the IRC, complainant specifically said that everyone in the Portland general area is a customer and knows that they're there, and that it just simply wasn't feasible. He also said during the IRC that supervisor was familiar with event rental, but not equipment rental, and didn't have the same level of expertise as supervisor. He also testified that supervisor was insecure that supervisor had never gone to college and that complainant has a college degree. The truth is that complainant reacted negatively when respondent took steps to implement the succession planning in the store manager role, ultimately creating a negative environment for customers and staff members, while also, again, undermining supervisor and leading to respondent's decision to part ways with complainant. Respondent presented evidence that complainant made comments about SM2 replacing him and pushing him out in front of SM2 and customers, and resisted training SM2, creating a negative environment. During the IRC, complainant himself admitted to making comments in response to customers busting his chops, but seemingly thought that because SM2 did not complain to him personally, that SM2 and others were not made uncomfortable. In reality, SM2 and others complained to supervisor and to respondent. SM2 testified that he personally witnessed the comments, which he characterized as inappropriate. SM2 further testified that he sought out training opportunities with complainant, and that complainant would tell SM2 he didn't need to worry about that now, and SM2 would therefore seek training opportunities from other. SM2 further testified that he, quote, he voiced these concerns to supervisor regularly. Simply, the finding of pretext is also belied by the facts that did not become part of the record, or the report, that respondent continued to employ complainant upon its acquisition of the company in 2021, and that the decision maker in both retaining complainant and separating his employment was the same. It was supervisor. Respondent also terminated the employment of SM2, a store manager, as store manager for inadequate performance in July 2024. SM2 was approximately 33. The current store manager is approximately 48. 3/4 of the company's employees are over 40. 1/2 is over 58, has a combined company tenure of 125 years, and the average age of the company's employees is 51. Those statistics are simply not the hallmark of an employer who discriminates against older workers. And I will reserve the remainder of my time. Thank you.
Commissioner, questions for Attorney Haley? Commissioner David.
Attorney Haley, nothing in your presentation suggests that there were performance issues justifying his termination.
There were, the termination is for subordination and for making others feel uncomfortable by making comments about the succession plan, and also for having kind of a stagnant performance. One example is that supervisor asked him to make outbound calls and to visit customers.
The termination is for insubordination for what? Not training the replacement that's been hired to push him out? Which is a loaded statement, I understand, but yeah.
You know, I obviously take issue
Right.
with that character. I know perhaps you didn't mean it that way, but I do take issue with the characterization. It's questioning supervisor's judgment. It's not following supervisor's initiatives. It's not training SM2. It's making people, customers and staff members uncomfortable. SM2 complained, other staff members complained. It's a, you know, the death by 1,000 paper cuts, not one particular.
Do you concede that hiring FM2 is being hired for that position in that store?
SM2?
Yeah.
There's just one location.
There, I'm sorry, I can't hear you.
There is one
Right.
location.
Okay.
Right. And so SM2 was hired to train under complainant and to work with complainant as a store manager. But
Another
not to
question.
place
What do you make of this indication that he's given an option to work until December 31st or what, leave then some 3 months earlier? And he says he'll work till December 31st and then they fire him.
Because supervisor and complainant had conversations in October that he was making people uncomfortable, and that he was going to let him work through the end of the year if he wanted to. And supervisor and complainant said that he wanted to work through the end of the year, and those comments continued. And so respondent made the decision that it would not have complainant come into the store anymore, but would continue to pay complainant through the end of the year.
Thank you.
Commissioner Douglas.
Yes, Attorney Haley, good morning.
Morning.
So I just to follow up on one of Commissioner David's questions, you say that the complainant was not terminated because of job performance issues, but the report expressly says otherwise. And I'm looking at paragraph 7A, where it says respondent asserted that the complainant was discharged because he failed to improve his performance despite receiving multiple verbal coachings from supervisor. And then the report goes on to say that that's not supported by the record. 2 years of employment and he never received any performance-related disciplinary action, just to quote the record. But you're now saying this morning that that's not an issue. That's not why he was terminated.
No. So paragraph 6 says that we articulated a non-discriminatory reason for the discharge, which was because he failed to meet respondent's performance standards, failed to train SM2, was insubordinate, and failed to improve his performance. Supervisor complainant met weekly over the course of years, and supervisor did convey to complainant that there were areas where his performance could improve, and there was also issues with insubordination, both prior to and after the hiring of SM2.
Okay, I'm just highlighting that's not that doesn't appear to be exactly what's in the record, what's on the report. So, okay, thank you.
Other commissioner questions for Attorney Haley? Okay. Seeing none, Attorney Haley, you'll have 52 seconds when we come back to you.
Whopping 52.
Sure.
Thank you so much.
Attorney Cotter.
Morning, Commissioners. Thank you for the opportunity to speak today. I represent the complainant, Eric Leffler, in this matter, and I'd like to reserve 2 minutes for rebuttal, or let's actually just make that 1 minute now. So the investigator made no errors here. Mr. Leffler proceeded pro se through this process up until after the recommended decision was issued. And the record below is robust. Mr. Leffler provided ample evidence through which a jury could certainly find in his favor in a civil action. But where the record is lacking is any contemporaneous evidence whatsoever to support respondents' position that Mr. Leffler was terminated for legitimate performance reasons, the reasons that are stated in paragraph 6 of the report. Succession planning is not on its own an unlawful act, of course. But when you use succession planning as a veneer for pushing out an older employee and replacing them with somebody who's 35 years younger than them, then it just becomes a pretext. So Attorney Haley mentioned the May 2023 meeting where the supervisor, the vice president of the company, learns that Mr. Leffler is 66, and he was surprised. He expressed surprise. At the IRC, supervisor testified that, well, yes, he could have, prior to this date, found out Mr. Leffler's age, but he did not state that he knew that Mr. Leffler was 66 prior to this May disclosure. And this really was the triggering event here that set in motion all of the things that happened over the course of the next 5 months. Prior to June of 2023, Mr. Leffler had been involved in all interviews and hiring at HMR, at Handyman, including about 9 positions that he helped fill after the acquisition by Eastern Events in 2021. Now, he was not included here in hiring the store manager position, which was his position. The interview was performed while he was on vacation, and supervisor said that it was ultimately or eventually. I think that there's a distinction without a difference there in how supervisor testified on that point. Ultimately, that SM2 would be reporting to him, so he didn't need to include Mr. Leffler in the interview and hiring position decisions. So that makes no sense if you also consider it in conjunction with respondents' position that there was no timeline on Mr. Leffler's retirement. They've suggested that he said that he was going to retire in 6 months, and they go as far as to say that he admitted it at the IRC. The quote that's provided in respondent's objection certainly doesn't support that, but for additional clarification during the IRC, Mr. Leffler came back to that point and said it was not true that he said that to the supervisor. He did not keep changing his timeline. He never said he was going to leave in 6 months. He had no intention of leaving in 6 months, and that quote was taken out of context. The context of that discussion was Mr. Leffler saying that in the winter of 23 into 24, he was looking to take additional time off to travel with his wife. So that's assuming that he intended to stay employed during that time. And the 6 months is in reference to the previous owner's wife, who was diagnosed with mesothelioma, and she was 55 years old and she ended up passing within 6 months of that diagnosis. And that's why he said, life is short. I do want to spend some time with my wife and go traveling with her. It certainly had nothing to do with his retirement age, and the record is extremely clear on that. So in July of 2023, supervisor hires a 31-year-old individual into Mr. Leffler's position. And supervisor tells him, oh, we're going to keep him on the counter because they had just let go of a counter person until December. But a counter person is hired at $20 an hour at this establishment, which is 9 to 10 employees. It does not require 2 general managers to run the show. And so if they're going to keep him at the counter until December, what happens in December? What is the event that they're anticipating? And exactly what happened would be that event that Mr. Leffler was let go. He trained this individual, and when he finished training him on the billing procedure, that's when Mr. Leffler was fired. I want to go back real quick to this notion that the succession planning was anticipated or discussed as far back as 2021. And I think Attorney Haley said that they had a discussion in 2022. There's absolutely no evidence of that. The first evidence is consistent with Mr. Leffler's testimony and his positions, was that it came up in January of 2023. And at the time, there was no discussion of Mr. Leffler wanting to retire. He never shifted the goalposts and changed his retirement date. And even after they hired his replacement testified that Mr. Leffler told him that he was looking at least 5 years, 5 to 10 years that he planned to stay around. None of that has any bearing on the decision to terminate, at least the purported reasons for terminating Mr. Leffler's employment, because there is no record of performance deficiencies whatsoever. And without that, their reason just falls apart. Okay. Mr. Leffler and supervisor communicated frequently by text message, and Mr. Leffler provided that to the commission. It's in the record. And I think this is another example of what you don't see in that. And what you don't see is any mention whatsoever of performance issues, insubordination, failing to train SM2. It's just not there because it didn't happen. And if you look at Mr. Leffler's performance record, just the year prior, he scored a 96 out of 100 in his performance evaluation. This was not somebody who was struggling. He was doing an extraordinarily good job for the company. And finally, this same actor position that respondent raised is distinct from how that's generally analyzed. He was not hired by Eastern Events. He was inherited when the company acquired Eastern Events. They sent a letter that said, "We looked at the business. You guys are doing a great job. We don't intend to change anything." The only thing that changed was that in May of 2023, supervisor found out how old Mr. Leffler actually was, and that's what started the ball rolling on pushing him out. This supervisor was hired not as a trainee. He was hired at $75,000 a year, and that's not something that makes logical or business sense for a company to hire an individual to do the exact same job as an existing employee. If there,
Attorney Cotter,
yes,
that was 9 minutes.
Okay, great. I'll take any questions from here and I'll reserve.
Okay. Commissioner questions for Attorney Cotter. Okay. Seeing none, you'll have a minute And we'll go back to Attorney Haley, who has 52 seconds.
I think it's important to highlight again that there have been at least 3 other succession plans where people are not hired with the word trainee, and those employees have coexisted for years. And it's not for Attorney Cotter or for us to judge what is logical or business sense with how a company wants to compensate its employees. Also, respondent did hire a complainant. It retained a current employee, but it certainly made a decision to keep that current employee. And of course, would have had access to employment records at that point, including complainant and any other employee's age. Thank you.
Commissioner, questions for Attorney Haley? Okay, seeing none, we'll go back to Attorney Cotter, who has 1 minute.
Thank you. Just a note on the 3 other succession plans. Those succession plans did not hire one-to-one into the positions that they were intended to succeed. I believe they refer to the 2 mechanic positions, and they brought somebody in certainly initially as a driver. And that he was paid as a driver. But because of this notion that the senior mechanic at the time would someday retire, they did start cross-training that driver in the mechanic position, but there was no, he was not hired certainly to be the senior mechanic. He was a driver who, when there was time, trained in this other position. There was no additional compensation for that.
Commissioner David.
Attorney Carter, I'm just curious. I realize that it's your position that it doesn't apply to this case, but is there a way for them to do it properly, to create a succession plan for the new owner to then adopt a policy for retirement age or something like that?
Certainly. I mean, they could have hired a counter person to do the same thing that they did in the mechanic situation, where you hire somebody to start cross-training. It's not an urgent thing. I mean, the focus on training SM2 was extremely strong. And I will just say that SM2 did not, his testimony didn't support respondent's position here that Mr. Leffler refused to train him. He just said that he had to be proactive to learn new things. But there was a really strong push to get this person up to speed in just a matter of months, which again makes very little sense when considering the fact that there was no timeline on Mr. Leffler's retirement. And so there was ample time to slowly train this individual.
Yeah, I mean, I understand that argument. I'm going far afield in my own thinking about it. Thank you.
Any other commissioner questions for Attorney Cotter? Okay. Seeing none, thank you both. And next we'll hear from Nupur Leva, the investigator assigned to this case.
Good morning again, commissioners. I don't have anything to add that wasn't in my report. The parties have represented their cases just as they did to me. Based on everything that was provided, my analysis is laid out in my report as I would lay it out to you today if I was making this argument to them.
Commissioner, questions for Investigator Leva? All right, seeing none, thank you, Nupur. We've heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding.
I'll move that we find that there are reasonable grounds to believe that respondent discriminated on the basis of age and conciliation should be attempted.
Second.
Moved and seconded. Any discussion?
Age is a difficult thing to show discrimination about because it's so subtle. But I think this is a classic case in which it has been shown, the hiring of a person for that position and the continued pressure to push him out. It's based on his age. There's no evidence of any other performance issues, and respondents' position is that we're to believe that the performance issues were not going willingly to the slaughter. It's age discrimination.
Any further discussion? Seeing none, the motion is to find reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
All right, so the findings are reasonable grounds, and the commission will send a letter to the parties and council confirming the next steps.
And the last case for hearing before the commission this morning is E240002, Amy Beth Hurst versus Town of Old Orchard Beach.
Okay. Is there anybody here for Ms. Hurst? There was so as background, this case was originally scheduled to be heard in October. Attorney Uhl let me know quite timely that he would not be available for that date if the complainant did submit her statement of disagreement with the report, which she did. So we tabled it. I believe I sent an email to the parties on October 8th, letting them know that we would be tabling this case until December 1st. Complainant received that email. It went to the same email she's been getting emails at during the whole case. She reached out to investigator Brindley this morning, saying that she had no idea that the case was on for today. She was very surprised. Alex sent her the meeting information and the Zoom link this morning, even though she already had it. She received the hearing information for today when it went out to all the parties. You do not see her here. The only person I think, so Fran Bolu, I'm sorry, I cannot see your whole name. I assume you are here for Old Orchard Beach. Is that correct?
That's correct. That's correct, Kit. Fran is here for Old Orchard Beach.
Okay, and I see somebody here named DeSanza, and I don't know who that is.
Diana Asanza, I'm the town manager.
Okay, great, thanks. So I do not see Ms. Hurst, although she has had notice many times of today's hearing. This is a no reasonable grounds case, so we would be hearing from her first. Commissioner David?
I just wanted to hear from Alex. You talked to her this morning. Is there any, did she indicate there was some reason that she could not join this morning?
Sure. So I emailed her and then I followed up with a phone call just to make sure she had received my email. We spoke briefly. She told me that she had in fact received those emails, but got lost in her list and likely wouldn't be able to make it today, but did not ask for a continuance or anything.
But didn't give you any specific reason that she couldn't?
She had another appointment today.
Thank you.
Thanks.
So generally, if the complainant doesn't appear in a no reasonable grounds case, same as if a respondent doesn't appear in a reasonable grounds case, we would default to the investigator's findings unless commissioners have any questions about this.
No, it seems as though we've given her ample opportunity and she doesn't quite want to make the presentation.
Okay. In that case, I would be looking for a motion. There are two proposed findings. Commissioner O'Brien?
I would take them together that there are no reasonable grounds to believe that the town of Old Orchard Beach retaliated against Amy Beth Hurst for engaging in MHRA protected activity and WPA protected activity, and the complaint should be dismissed. Accordance with 5 MRS 46122.
Second.
Jinx. All right, moved and seconded. Any discussion? Okay, seeing none, the motion is to find no reasonable grounds on both recommended findings. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. All right, so the findings are no reasonable grounds, and the commission will send a letter to the parties confirming the results of the hearing.
And
Yeah,
that
go ahead.
completes that completes the hearing agenda. That's what you're going to say, Kat?
Yes. Yep.
So I'll make a motion pursuant to 1 MRSA section 405(6)(e) that we go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
Moved and seconded. Any discussion? Seeing none, if you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. Just having the time. All right, I'm going to invite you all to a breakout room. Unmute myself. There we go. All right, so I need a motion not to litigate E230271 Bianca versus Central Maine Pediatrics or E230292 Moulton versus Lockwood Hills Federal.
So moved.
Second.
All right, if you, any discussion? If you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien?
You're muted, Julie.
Sorry, yes.
Commissioner Douglas?
Yes.
Okay, and Commissioner Sanders?
Yes.
Technically, you should be on video, I think.
Sorry about that. The way my other device is configured, the camera doesn't turn on.
Okay. Then I need approval to sign the updated agreement in H220144 Fakori versus Manuel/Burnham Brookside.
So moved.
Thank you.
Second.
Okay, any discussion? Seeing none, Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay, and lastly, to approve the agreement in Leba v. Wallace, H230314.
So moved.
Great.
Second.
Thank you. Any discussion? Seeing none, Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
All right. With that, everybody have a wonderful holiday season, and we will see you in the new year, if you can believe it.
You as well. Stay
Okay.
safe, everybody.
Yeah.
Okay.
likewise.